Just want to say thank you everyone for joining me today on our webinar in relation to the job support scheme. I'm aware from previous conversations that a few people have got some questions that they want to ask. More than happy to answer those if I can, I think it would be best if we could do that at the end. There is the chat function, so if you do want to pop any questions in there, the rest of the Guardian team will be able to answer things as we go along. I have sort of put some slides on the screen that you can see. I'm going to try and stick to them as best I can, but obviously I'll be expanding on them and might go off on a tangent, but I'll try and stick as closely as I can just to make sure that we cover everything. So the main purpose of the talk today is just to go through the job support scheme and to cover in a little bit more detail as to how that's going to work. I'm also going to be covering sort of some options that you have other than the job support scheme, including things like layoff and short-time working, change in terms and conditions, and redundancies. So the job support scheme, what is it? It's effectively a scheme that's been introduced to replace the furlough scheme. So the furlough scheme is due to end on the 31st of October, and the job support scheme has been brought in by the government to replace it. And the aim of the scheme is effectively to protect what the government has described as viable jobs. So it's to protect businesses who continue to be affected by the pandemic after the furlough scheme comes to an end. The word viable has been talked about quite a lot in relation to the scheme, and I think businesses have to consider before joining the scheme as to whether or not the employees that they're intending to put onto it are in positions which are viable. So it's definitely something that you need to think about, particularly given that the government has said that it's likely to review the requirements of the scheme sort of in January, February time. So it may be that the minimum requirement for the hours to be worked increases. So that's just something to bear in mind. The job support scheme is split into two categories. So we've got the open job support scheme and the closed job support scheme. The scheme that you would claim under depends on whether your business is forced to close as a result of the lockdown or whether it remains open. So there are two options available. I'm going to talk more about the JSS open scheme, but I will touch on the closed scheme as well, because I appreciate that some people have businesses that might be affected by it. So the open scheme can be used where your business can continue to operate, but you're facing a reduced demand and you don't need your employees to work the normal contracted hours. So what the scheme is intended for is to enable you to keep those employees in work rather than look at redundancies. But as I said at the outset, it needs to be a viable job. So I think businesses really need to consider at the outset whether or not those jobs are viable, because if they're not, and they think actually even in a few months' time I don't think we're going to be able to return the employee to full time, then it might be that the scheme isn't the right option for you. Under the scheme, an employee will need to work a minimum of 20% of the normal working hours. Now obviously that's changed as of last week. It was a third of the normal working hours. That's now changed to 20% of the normal working hours. And essentially how the scheme works is that for those hours that the employee works, you will pay them as normal for their worked hours. For the hours that the employee doesn't work, what happens is the government pay 61.67% of that and you pay 5%. So effectively the employee is getting paid for 2/3 of the hours that they don't work. The balance, so the remaining third, the employee agrees to forego. There are caps on those contributions. So as it says there on the slide, you pay a maximum of 5% of the salary for the hours not worked, and that's up to a maximum of £125 a month. And the government pays up to a cap of £1,541.75 per month. And another important point to note is that you need to fund the full NI and pension contributions on the total amount that the employee receives. So unlike under the furlough scheme where that could be included within the claim, up until obviously the changes over the last few months, you need to be aware that that needs to be funded by you. And one thing that I will comment on the employer contribution in relation to the 5% is that it says there on the slide that it's up to an employer as to whether they top that up. So like furlough, where employers could top up the salary of their employees. At the moment, the government are saying it's their expectation that companies don't top up. And I guess you can sort of understand that, because obviously if a company can afford to top up their hours, top up the pay for the hours that the employee's not working, then why would they not actually just make them work more hours and pay them accordingly? So I think the expectation is that companies won't top up, although the guidance doesn't, at the moment, it doesn't seem to suggest that you cannot top up. So I've given a bit of a worked example here of the open scheme and how it would work. So Sam is employed by Blogs Limited. He gets an annual salary of 36,000 and 3,000. So that equates to £3,000 a month. So in a normal month, he'd work 225 hours, which is £13.33 per hour. And under the scheme, he's agreed to work 45 hours a month, which is effectively 20% of his hours. So he gets £600, and that's paid by the company. To qualify under the scheme, the company, so Blogs, must pay Sam for 5% of his remaining normal hours. So that's 5% of the hours he doesn't work, which in this case is 9 hours. And then the grant would cover the cost of 61.67% of the total 180 non-working hours. And it sets out the calculation there as to what Sam will receive, and effectively he's receiving 73.33% of his normal pay. At the bottom, it just confirms that the company bears the cost of 720, which is the 600 for the hours that he does work, and 120, which is 5% of his non-working hours, plus the employer's NIC contributions on the whole amount, and any relevant workplace contribution. So that's an example. There is lots of guidance on the government website about how to make your calculations, but that's just a worked example in relation to it. So how does the closed job support scheme work? This scheme is intended to cover businesses that have been forced to close as a result of either a local or a national lockdown. It doesn't cover where a company decides that it's no longer viable to continue trading because of a downturn. It doesn't also cover situations where a workplace is forced to close as a result of an order by a local health authority. For example, if there's been a workplace outbreak of COVID and the premises are asked to close by the local health authority, unfortunately you cannot claim under the closed job support scheme. It's only if your business is forced to close as a result of a local or national lockdown. Under this scheme, the employee will receive 2/3 of the normal wages, which is fully funded by the government, and there is a cap on that. So the cap on that is £2,083.33 per month. Like the furlough schemes, employers can top up their employees' pay if they wish to, but there is no obligation. So another example on how the closed scheme works. So Charlie is a chef employed by Ronnie's. He's on a salary of 32,000 or £2,666 a month. Ronnie's Burger Bar is closed as it is located in a Tier 3 zone. So Ronnie can claim 2/3 of Charlie's salary at £1,777.78 under the scheme. But Ronnie will also have to pay the employer's NIC on that salary plus the minimum employer's contribution if Charlie's not opted out of the scheme. So Charlie will therefore receive £1,777.78 before his tax and NI contributions. So obviously from that perspective, it's relatively straightforward in how to calculate what an employee is entitled to under the scheme. Now, that's just in a nutshell how the schemes work and how they work from an employee's perspective. There are certain criteria that companies need to fulfil to be able to make claims under the scheme. So the first thing to note is you don't have to have used the furlough scheme previously to use this scheme. It is open for 6 months, so it starts from the 1st of November until the end of April. But there is a potential for it to be reviewed in 3 months to determine whether the thresholds will need to be reviewed. So at the moment, we've got the 20% minimum hours to be worked. There is talk that that will increase in 3 months. Whether or not it will, I guess, will depend on how things sort of work out with the restrictions that are in place. The other eligibility criteria are that you must have a UK bank account and a PAYE system in place to be able to claim the grant. Small and medium-sized businesses can apply without a financial assessment. That's been deemed in the current guidance to be employers who employ less than 250 employees. If you employ more than 250 employees, you're classed as the large business and you'll need to meet a financial assessment test. That's, in essence, you need to be able to demonstrate that your turnover has been affected as a result of the pandemic. There is quite a lot of guidance, again, on the government website about what that impact test entails. Employees also have to be on the payroll on or before the 23rd of September, so they need to have been on your payroll between the 6th of April 2019 and 11:59 p.m. on the 23rd of September 2020 in order to be eligible. If you have employees who were on the payroll at that time but have subsequently been made redundant, or you've let them go, then at the moment it's saying that you can rehire those employees and put them on the scheme, but they must have been on payroll on or before the 23rd of September. It's also been confirmed that you can claim both the open and closed grants at the same time for different employees. So it may be that part of your business has been forced to close, in which case you can claim under the closed scheme. Other parts of the business which have remained open, you would be able to claim under the open scheme, but you can't claim under both schemes for the same employee. One other thing to bear in mind is that the government has confirmed that they are going to publish a list of companies that use the scheme. I guess it's a way of naming and shaming. What effect that will have, I've got no idea, but that's something that's sort of been commented on quite a lot. So those are the criteria. What other things do you need to be aware of under the scheme? Well, under the scheme, it is effectively a variation to an employee's terms and conditions, so it's a variation of contract, so that needs to be agreed. You can't force an employee to go on the scheme, so you need to get their agreement. The guidance again is saying that you need written agreement, so as with the furlough scheme, best practice and the best thing you can do if you do want to use the scheme is get an agreement in place with that employee before you want to start using the scheme. The scheme at the moment, the claims can be made from, and it's the later of two dates, either the date they start working the reduced hours or the date you get a written agreement. So if you put job logs on reduced hours from the 1st of November, but you don't get a written agreement until the 10th of November, unfortunately, you won't be able to make a claim for the period from the 1st until the 10th. So best piece of advice is get the agreements in place before you want to reduce the employee's working hours. A couple of other differences from the furlough scheme is if you're claiming the grant for an employee, you can't make the employee redundant and you can't have them on notice during the scheme. So unlike the furlough scheme where you could go through a redundancy process and you could serve notice on an employee to end their employment and claim part of their notice pay under the furlough scheme, you're not able to do that under the new job support scheme. There's a lot of commentary about whether or not you can go through a redundancy consultation process and keep them on the scheme. And I think a lot of people are tending to think that you can, and I would probably agree with them unless the government brings out guidance to suggest otherwise. But as soon as you reach the point where you want to serve notice on an employee to end their employment, they would need to come off the scheme. As I've said there, you need to obtain your employee's agreement to reduce their hours. Claims are made in arrears, and I believe it's from the 8th of December. So initially, employers are going to have to make the payment to their employee and then claim that back on the government. It's going to operate in a similar way to the furlough scheme in that claims are submitted online, but they're paid on a monthly basis, and it's paid in arrears. A couple of other things that are worthy of mention on the scheme is that the hours that the employee works needs to be for a minimum period of 7 calendar days. So they can work 20% for 7 days. You can then change that to 30% for the next 7 days, or 50%. They can come off the scheme and go back on the scheme. So it's fairly flexible in terms of how it operates, but you just need to be aware that any working pattern needs to be for a minimum of 7 calendar days. So what actions do you need to take to benefit from the scheme? As I've already touched on, you need to obtain your employees' agreement. So you need to speak to them. You need to be honest, you need to be transparent, and you need to explain to them why you need to put them on the scheme. Second thing, a job support scheme agreement. Get your agreement from your employees in writing, because it's already been confirmed that HMRC are going to be carrying out audits to make sure you have got written agreements, and that you need to keep those for 5 years. So make sure you've got a clear audit trail and clear written agreements from your employees, and that they've agreed to the change to the terms and conditions of their employment. You also need to decide who you're going to put on the scheme. Now, it could be that you put all of your team or an entire department on the scheme, or it may be that you have to select those from a particular team that you want to put on the scheme. The issues with that, where you've only got a certain number of employees that you want to put on the scheme, is how do you choose the ones to put on the scheme? Guidance has been suggested that you should go through a sort of selection process, a bit like you would on a redundancy exercise. It's deemed to be the fairest way, and it avoids any claims of discrimination for those that are either that get put on the scheme and are not happy about it. You can also ask for volunteers, which is often a good way to do it, which I've said there. So that obviously will depend on the number of employees you want to put on the scheme. So you may want to consider asking for volunteers. So a couple of other bits before I go on to alternatives in relation to the scheme, as follows. A lot of questions have been asked about how do you deem what an employee's normal working hours are, because the guidance refers to an employee working 20% of the normal working hours. The starting point is to look at your employee's contract of employment. That will normally set out their contractual hours. The scheme can, however, be used by 0 hours workers or employees who work variable hours. If an employee works fixed hours, then you look at their contracted hours for the last pay period before the 23rd of September or before the 19th of March this year. So whichever is the highest, then that's the normal hours that you use. If somebody works variable hours, then it's a little bit more complex in how you work out normal hours. So in essence, it's the higher of the hours that they worked in the same month last year, or the average of the hours that they worked in the whole financial year 2019-2020, or the average hours that they worked between the 1st of February 2020 and the 23rd of September 2020. So it's the higher of those figures. As I say, there is quite a lot of useful guidance on the government website about how you calculate normal hours. Another question that comes up quite a lot is in relation to what salary you use. So what is reference salary? The government has confirmed that regular salary includes regular wages that you would be obliged to pay, non-discretionary overtime, commission payments, piece rate payments. So again, it's broadly similar to how the salary that you would use for calculating furlough claims. Excuse me. Couple of anomalies. If you've got an employee who is on a fixed rate of pay, then again, you look at the higher of either the wages in the last pay period before the 23rd of September or the last pay period before the 19th of March. And if somebody's pay varies, then again, it's the higher of the same month last year, their average earnings for 2019-2020, or their average earnings between the 1st of February 2020 and the 23rd of September 2020. And that is basically how you look at normal working hours and reference salaries. As I say, I'm not going to touch on in any more detail on how you make the calculations, because you'll all no doubt be aware of how complicated it is, particularly given that that it's worked broadly in the same way as the furlough scheme. So it operates on a calendar day basis as opposed to a working day basis. But that's sort of the nuts and bolts of it at the moment. A couple of other things that I need to touch upon that comes up quite a lot is holidays and sickness and statutory leave during the job support scheme. So a question that's often asked is, what if an employee is sick? Can they go on the scheme? The answer to that is no. because if they're sick, they're not working, and obviously one element of the scheme is they need to be working 20% of their working hours. So if they're off sick, then they would be entitled to either SSP or company sick pay. Same goes with holidays. So if an employee is on annual leave for a week, they're obviously not working 20% of the normal hours, so claims can't be made under the scheme. You can have, obviously there are occasions where an employee might have one day off, in which case they can still work their 20% of the normal working hours. On those occasions, at the moment, it's believed, unless the guidance says otherwise, that you can make the claim under the scheme, but obviously you would pay them for their holiday as normal, so on their full rate of pay, and that would contribute towards their working hours. So that would need to be included in calculating how much of the working hours that they've worked. Training as well. So employees who carry out training whilst they're on the job support scheme should be paid at full pay, and that would count towards their 20%. So that's one other thing that we can confirm. The other issue is in relation to periods of statutory leave, whether that be maternity or paternity. Again, the guidance hasn't sort of clarified this yet, but it's believed that if an employee is receiving a statutory payment, then they're not entitled to be on the job support scheme. So if you've got somebody that's on maternity leave, then they will stay on their statutory maternity pay. As soon as they come off their maternity leave and return to work, you can then at that point put them on the job support scheme. Okay, so what alternatives are there to the job support scheme? So you might be thinking, well, the job support scheme actually doesn't work for me because I haven't got 20% of the hours, or I don't actually think that the jobs are viable. So there are a couple of other options available to businesses. One is layoff and short-term working. The other one is changing terms and conditions, and the other one is redundancy. So bit of a whistle-stop tour, but more guidance can be provided if you think you need some advice on any of these issues. So layoff and short-time working, what does it mean? So layoff is essentially where you're off work for at least one working day with no pay, and short-time working is where your hours are cut or reduced, and accordingly your pay is cut or reduced. There isn't a time limit as to how long you can put employees on short-time working or lay them off. But the caveat to that is, if an employee has over 2 years service and qualifies for a statutory redundancy payment, then if they've been put on short-time working or laid off for 4 weeks in a row, or a total of 6 weeks in a 13-week period, then they can make a claim for redundancy payment. One point to note on that is, for short-time working to qualify, they need to be on less than half a week's pay. So if they're working more than 50% of their hours, then the risk of them being able to claim a redundancy payment is mitigated. Under the layoff and short-time working, you pay the employees for the hours that they work. They also are entitled to what's called guaranteed pay, which is £30 a day and is payable for 5 days in any 3-month period. So it's not a great deal, it's £150 maximum. Layoff and short-time working is intended to cover short-term issues in a business. So perhaps where there's been an unexpected downturn in work, or something unexpected has cropped up that's meant that the demand is reduced for a couple of weeks, etc. Then that it's often a good mechanism to allow you to keep your employees in employment, but to lay them off. The only way you can do this is if you've got a clause in your contract that permits it, or if they agree to it, because it is effectively a change to the terms and conditions. So if you do want some further advice or guidance on that, then get in touch, because it is, as I say, there are circumstances where an employee can claim a redundancy payment from you if you do use this. Second thing that you can consider is changing terms and conditions. So this can be a temporary or a permanent change, and it's often considered to be a good alternative to redundancy. Changing T's and C's can include things like reduction in hours, pay, non-payment of bonuses or commission. Any change to terms and conditions needs to be agreed. So it needs to be agreed by your employee. The best way to get an employee to agree to change their terms and conditions is explain to them, have an open conversation, explain why you need to make the change, what change you need to make, and ask them if they've got any objections, any suggestions, because it might be that your employee can come up with an alternative to what you're proposing. Any agreed change, I would always confirm in writing and get your employee to sign to confirm their acceptance. One thing to bear in mind is if you're planning on changing the terms and conditions and it affects 20 or more employees, then this triggers what's known as collective consultation obligations. So within that, you've got minimum consultation periods, and the consultations are similar to those that you'd have in a redundancy situation. When trying to negotiate change in T's and C's with employees, it's often a good idea to consider what you can offer instead. So perhaps you can offer some sort of incentive that's not going to cost you in the short term. So perhaps you might be able to agree an increase in holidays or some other potential bonus, etc., that you could pay at a later date, that sort of acts as a little bit of an incentive for them to agree to the change to the terms and conditions. If you can't obtain your employee's consent to changing the terms and conditions, then the last resort is dismissal and re-engagement. That's quite a tricky one, and one that comes with some potential consequences, because if you dismiss and re-engage, then you run the risk of unfair dismissal claims if your employee has over 2 years service. And again, whilst you can do it, you know, it's more risky. And brings that risk with it. So what we always say is exhaust all options before you consider this, and if you did want to consider dismissal in the engagement, then take some advice before you do it, just so that you can be aware of the potential consequences and risks. So I'm now going to just briefly touch on redundancy, so the basics. So you'll probably all be aware employees that have got more than 2 years service are entitled to a redundancy payment. They can also claim unfair dismissal, so please follow a process when you go through a redundancy consultation. First thing in a redundancy is you need to make sure you've got a genuine redundancy situation. Typically that's where a business is closed or you've got a reduction in the need for people to do work of a particular kind. Once you've demonstrated that you've got a genuine redundancy situation, you then need to look at, well, who do you need to make redundant? Are they in a standalone role, or are they in a pool of employees? So say, for example, you might have 20 warehouse operatives, you only need 15, so you need to choose 5. So the relevant pool of employees would be the warehouse operatives. It's not always that clear cut as to what the pool will be, because it's not always just those doing the same role. It can include other people who do the same or similar roles, or those who have interchangeable skills. So it's something that you just need to give some sort of thought to. As a rule of thumb, you need to go through some consultation meetings with your employees. So we would often advise have a group meeting if it affects an entire team, and then follow that up with at least 2 individual consultation meetings. Redundancy should always be confirmed in writing, and I would always recommend giving a right of appeal. That way it flushes out any procedural issues or any issues that you might not be aware of as part of the process. As part of redundancy, you also need to consider alternatives. So consider the job support scheme, consider job shares, pay cuts, reduction in hours, and also remember that in a redundancy situation, you've got a duty to consider alternative roles that might be available within the business. As I've touched on previously, unfortunately, you can't use the job support scheme grant to cover any redundancy payments or notice pay. So those are costs that you are going to have to bear if you want to go through a redundancy process. Briefly just touch on selection criteria in a redundancy process, because this is something that comes up quite a lot. So you've got your 20 warehouse operatives, you need to lose 5 of them. How do you make that choice? You need to draw up selection criteria. These criteria need to be objective as possible. So things that you can include that are objective: sickness absence, but bear in mind you can't use any long-term health absences, because that's potentially discriminatory on disability grounds. You can look at disciplinary records, performance, timekeeping. Selection criteria will differ depending on the role, because it may be for a particular role you have a particular skill or qualification that's required, so those are always good criteria that you can use. Make sure that you can back up the scores that you give with evidence, which is why we always say try using objective criteria. If you've got something that you can evidence either through appraisals, disciplinaries, performance documents, KPIs, then those are always the best way to go. I always advise clients as well that selection criteria should be sent to the individual employees prior to the meetings, just so that you can go through that with them in the meetings and allow them to raise any objections or comments. Scoring should always be carried out by 2 managers if possible. That avoids any allegations of bias. And then those that are provisionally selected for redundancy should be allowed to see the score and be allowed to challenge them. So you need to be prepared to review scores before you make your final decision. And as I've said again at the bottom, confirm your decision in writing and allow a right of appeal. So that is essentially the job support scheme and alternatives to it. Another question that I just want to touch on in relation to the alternatives is the change in terms and conditions and how that interacts with the job support scheme. I think it's going to be more difficult for companies to agree changes to terms and conditions with employees now that the job support scheme is in place, because arguably under the job support scheme, the employee is being paid for more than the hours that they work. Whereas if you agreed a change to an employee's terms and conditions, say for example, you reduce their hours to 50%, they would only receive that 50%. So it's probably less likely for an employee to be able to want to agree to those changes, because ultimately they're going to be better off under the job support scheme. So what are your options in that situation? I guess the only options are you would consider the job support scheme. If that wasn't an option and you did want to enforce the change to terms and conditions, dismissal and re-engagement. Your dismissal would be on the grounds of some other substantial reason, but as I've said previously, that does bring with it the risk of unfair dismissal, so it needs to be something that's thought about really carefully. So yeah, I think that covers everything. So I've managed to run through most of what I wanted to cover. I appreciate that I have gone slightly over the half an hour, and people may want to or may have to leave the seminar now, but if anybody has any questions, then feel free to unmute yourself and ask away.
Hi, it's Lorraine. I've got a quick question.
Yeah.
Our guys have a contract which is fixed hours of 47.5 hours, I think it is, but they work variable hours each week of probably 50 or 60 hours. So when I'm working out their usual hours, which of the 2 scenarios do I go under? Although their contract is fixed, it's a lot less, they work a lot more on a variable basis. So do I use the variable basis to work out my usual hours?
Is the overtime contractual?
It's not contractual, but they do work it every single week. Because they're a building company and they're on site, they tend to work 6-7 days a week and will always do more than their 47.
Right, okay.
So when we sort of did the furlough scheme, it had to be based on what hours they usually work, which is the higher amount.
Yeah.
So should this be dealt with in the same way?
I think on the basis of the guidance we've got at the moment, then I would probably say yes, I would calculate it the same way as you did with furlough. As with a lot of these schemes that come out, we are still waiting on further clarification from the government, and it is expected that a Treasury direction will be hopefully brought out maybe tomorrow. They keep saying by the end of October. But I mean, at the moment, the only thing that we've got is the fact that if somebody is on fixed hours, which arguably these guys are, then it should be the hours that they worked before the 23rd of September or before the 19th of March, which arguably is the 47 hours.
Well, before the 19th of March, it would have been a 50-60 hour week, because they were doing their own, they were doing their normal hours, which is the higher of the 2.
Yeah, but but the guidance is currently saying that where you've got somebody on fixed hours, so they've got a fixed contract. Then you would look at their contracted hours as of 23rd of September or 19th of March.
Which, like you say, the contract does say only 50 47, sorry. So should I use that then, do you think? Or do we need to wait for the more guidance to be?
I think I would probably wait. What I would probably suggest that you do is, if you're wanting to speak to your employees about it now, then I would probably say, look, the worst case scenario is it'll have to be based on your contracted 47 hours a week. We are still waiting on clarification from the government as to whether or not we can use the overtime. Because I'm guessing that if it's discretionary overtime, then, you know, I suppose it would fall in, as I've said at the moment, the fixed hours, and should be based on the 47 as opposed to the other. I think it depends. I think that then, I guess, there's a bit of an overlap, isn't there, between normal hours and reference salary, because you can have somebody who's on normal hours, but if their reference salary includes regular, you know, overtime, then that would take that overtime into account. So I think probably what I would say, until we get some further guidance, is that you sort of do it on a worst case scenario. It's going to be based on your 47 hours a week. And obviously,
that's kind of my other question. Their reference salary, if we include the 60 hours a week, it would take them over that 37,500 sort of cap that they talk about. So does that mean they wouldn't qualify for the scheme at all, or you would just cap their unworked hours?
It doesn't mean that you wouldn't qualify for the scheme at all. It just means that their contribution from the government and from yourself would be capped at those levels.
Would be capped.
Yeah.
Right. Okay, that's fine. So I think I'll just wait for a little bit more
guidance. As I say, we're hoping that it's going to come out tomorrow, because there are quite a few anomalies that we're still not clear on. And I guess, like the furlough scheme, things came out afterwards that we all had to kind of backtrack on and clarify. So I think at the moment, if you want to have discussions with the staff, then do it on the basis of, you think at the moment that it'll be the fixed contractual hours, which is the 47 a week. And then, you know, if things changes, then obviously it's going to benefit them, but at least they'll know from their perspective that's the minimum that they're going to get.
Okay, that's great. Thank you for that.
No problem. Anybody else?
Hello, can you hear me?
Yes. Hello, Michael.
Hello. Yes.
Hello.
On terms and conditions, so somebody is working, say, 20% of the time. Do you change their contract of employment and job description to fit that 20%? Because somebody else, is it okay for somebody else to take on part of their work? You've got to reorganize everything, so somebody else might be taking on part of their work. So do you need to do, you know, new contracts, new job descriptions?
No, you don't need to do a new contract, but you need to have a written agreement in place from the employee to agree to reduce their hours. So that you'd have a bit like you did with furlough. You'd have a furlough agreement. So like on the job support scheme, you'd have a job support agreement, and that's a document that would set out that the employee is agreeing to go onto the scheme, that they're agreeing to reduce their hours, and that they're agreeing to accept the payments as calculated under the scheme, and then forego any balance. So you wouldn't issue a new contract of employment, but you'd issue a job support agreement that would act as a variation to the contract of employment.
Okay, and it's okay for somebody else to take over an aspect of their role that they might have been doing?
Sorry, Michael, just say that again for me.
Is it okay for somebody else to take over, say, an aspect of the role that they were actually playing, because it's essential to keep the company going?
I'm not too sure give me an example. What do you mean?
So for example, you've got a financial administrator who updates QuickBooks, who pays wages, who does etc. So you put your financial administrator on the JSS, and let's say you assign them the role of updating QuickBooks. Somebody else needs to pay wages, for example.
Yeah, you can do that.
Yeah. Okay, that's fine. Thank you very much.
No problem. Any other questions?
Hi, yes, Fiona, one from me.
Hello, Fiona.
Hi, I just wondered if there is any form of means testing. So, for example, if a net monthly salary is over the capped limit. So is there any point in actually claiming the JSS? Because I know it's just for the hours not worked, but if it's capped, is there kind of a top level salary that they wouldn't apply?
No, there isn't any cap on the salary level, but obviously for those that are higher earners, they are going to be agreeing to forgo more of their salary than somebody that's on a lower salary.
Yeah, okay. No, that's great, thanks.
Okay. Anybody else?
Sorry, just me, Claire.
Hello, Linda.
Hello. Could you just confirm about the holiday? I didn't understand what you said, and I think there was somebody else in the chat box that just asked a question about holiday as well.
No problem. Yeah, so we haven't got any clear guidance. We haven't got any guidance from the government in relation to how holidays will interact with the job support scheme. But if we look at the eligibility criteria that we currently have, so an employee has to be working a minimum of 20% of their hours. So if you have an employee who takes a week's holiday, they are obviously not going to be working 20% of the normal working hours. So they will not able to be on the scheme, and you will not be able to claim the grant for that week's holiday that they're on. Their holiday will then need to be paid as normal as they would if they were working. We think that if, for example, an employee just takes the odd day here and there and is still able to work 20% of their working hours, then that would mean that they would be eligible to participate in the scheme. Does that make sense?
Yeah, so we have to keep looking at this 20% each calendar days.
Yeah, 20% in 7 calendar days.
So going into a Christmas shutdown or going into a Christmas period or the bank holiday period, looking ahead in December, January, we're struggling with a lot of people where we normally have a shutdown.
Yeah, because they're not working hours. So you wouldn't be able to claim under the scheme. As I said, that's the thought process at the moment, unless the government comes out and clarifies it, a bit like they did with furlough. There was a whole, bit of confusion in relation to how the furlough scheme worked with holiday and whether you could take holiday during furlough. At the moment, on the basis of the guidance that we've got, that's how I would explain how it works. So,
it's just bonkers. There's people that need to be having the discussions with their employees here and now, and especially with weekly paid employees, you're effectively trying to have a discussion now for people who are going to be paid effectively for their hours next Friday.
Yeah,
it's a crazy position to be putting employers in.
I know. It's obviously it's improved obviously as of last week from the third contribution from an employer's perspective, but yeah, it's still has got some teething problems and some issues that need to be resolved in relation to how it's all going to work, really.
Can I just ask one other question, please? Obviously, we're a building company, so our work changes sort of all the time. So at the moment, most of the workforce are employed, but say once the site finishes, a lot more employees could be on it for 1 week, 2 weeks. It doesn't matter how many come off it, as long as everything is reviewed on a 7 calendar days, that's okay, isn't it? It can be 1 employee 1 week on it, none the next.
Yeah, it just says that you must have some or all of your employees on the scheme. So employees can cycle on and off the scheme as long as they're on that working pattern for 7 days.
So at some point, my weekly employees, they might all have work. So I'd have no weekly employees on it, but some of the office staff would be on it still, but that's okay.
Yeah, as long as you've got some or all.
So if at any point I'd got none on it, obviously I wouldn't make a claim, but the next week I could make a claim. Yeah. Would that be correct?
Yeah, that's my understanding. That's how it reads at the moment. So yeah, because you don't have to, the scheme opens obviously on the 1st of November, but as far as I'm concerned and what I've read at the moment, there isn't anything that says you have to use it from that date, because it might be that you've got work for them the first week in November, but from the second week in November that might change. So I think it's hopefully is going to work fairly flexibly, other than that condition that it needs, that working pattern needs to be for the 7 calendar days. Yeah.
I think that's answered all my questions for now. Sorry, Linda, I might bombard you later if I think of anything else.
Or feel free to get in touch with us. I mean, as I say, when any updates come out in relation to any Treasury directions or guidance, then keep an eye on our website, because we do post quite regular blogs on there as well. So as soon as we get any more information, particularly around issues with holiday, etc., or any further guidance on how it works, then we will post updates. But as I say, please don't hesitate to get in touch with us. Our email was on the screen, so support@guardianlaw.co.uk, or give us a call.
Okay, that's great, because I think my only concern is that usual hours thing. So like I say, I've kind of got to wait for the extra guidance to come out on that before I can make a decision on it, really. So, okay, that's great. Thank you very much for your help.
No problem.
Thank you.
No problem. Have we got any other questions? No? Okay, well, on that basis then, I'm going to end the webinar, but I'd just like to say thank you very much for everyone's joining us this morning, and thanks for all your questions. And as I say, if anybody's got any questions, then please don't hesitate to get in touch.